Good morning. Happy Sunday to everybody out there. And thank you for joining us today on Brother Counsel Sunday morning show. It's becoming a weekly thing, at least for now. We'll see if this continues, but definitely throughout the Karen Reed case, we've been having our Sunday show generally with Solomon, national trial attorney Solomon Radner, civil rights expert. And now that the Karen Reed verdict is in, he's licking his chops. Maybe he's going to get that phone call and start suing the entire state of Massachusetts. So we'll see if that happens. But today we're going to have Solomon for just a little bit of time. Unfortunately, he's got to run. But we wanted to bring him on just a little bit because I know how much everybody loves him and likes his takes. But really, the conversation is mostly going to be centered around Father Counsel because he's going to be making his first debut, his first appearance on Brother Counsel this morning for the Sunday show. So obviously there's been a lot going on. We'll probably get more into it with Mark Bederow. Mark Bederow is going to be joining the show also, but Mark is going to be joining a little bit later because we're going to have the Radners on first. We're going to have Father Counsel, Brother Solomon, myself. We're going to be talking about the civil case. And then a little bit later on in the show, we're going to bring in Mark and we'll talk about some more stuff about the Karen Reed case. So first, without any further ado, because I know he has to go soon, let's bring on national trial attorney, civil rights expert, Solomon Radner. Happy Sunday to you, Solomon. Are you on? I can't even see if you're on or not.
I can't see myself. Can you hear me?
Let me try this one more time. We'll try this again. And I guess we can hear you.
You can hear me?
I can hear you. Okay. I just don't know why we can't see you. But I can hear you.
Let me jump off and try again.
Okay. Sounds good. Well, and while Solomon's getting that worked out, let's see. StreamYard is going to give me an issue with bringing up Father Counsel. So for the first time also, again, making his debut, I hope we don't have any technology issues right now. We got Father Counsel himself going by the legal name of Howard J. Radner. And Father Counsel, welcome to the show.
It's a pleasure to be here, and thank you for having me.
All right, sure. Okay, great. So I'm going to try to get Solomon on one more time. Let's see if this works. There we go. We got Solomon.
There we go. Now it's working.
Okay, so, people have been asking, they like to be a fly on the wall when we have our dinner tables and our dinner conversations. I guess this can kind of be a little bit of an insight into what happens. We're going to talk a little bit about the civil case, but before we do, I want to just ensure and give everybody the confidence that they're talking to someone who's been involved in civil litigation for quite a while. So, Father Counsel, can you give us a little bit of a background on your own experience as a trial lawyer, as a civil litigator, kind of walk us through kind of your career a little bit just so that people can understand that you actually have the credentials to talk about civil litigation?
Well, sure. As you know, it goes way back a long time. When I was a little boy, my father used to discuss law all the time with me because he had gone to law school. He didn't practice law. He went into business instead during the Depression era. And he, was always discussing law cases with me as I was a little boy growing up. And I was always interested in the law. And so naturally, that's the field I gravitated into. And I became a lawyer in 1974. And I'm still practicing law now, 51 years later. And I love every minute of it.
Yeah, I know you do. So it's 1974 when you first started out your career. What did you start out as?
So I started out working for a defense attorney who was defending the uninsured motorist fund here in Michigan. Back then, the insurance coverage was not mandatory. And so when people would get into an accident with an uninsured driver, it was a waste of time to sue the driver because he was uninsured and uncollectible. So the state created something called the Uninsured Motorist Fund. And then the state hired a bunch of attorneys under the supervision of the Attorney General of the state of Michigan. And they were called Special Assistant Attorney Generals. and they defended the fund so that if somebody got injured by an uninsured motorist, he would sue the driver who was uninsured, and then he would notify the fund, and then the fund would appoint an attorney. I worked for one of those attorneys as a defense attorney, defending auto accident cases on behalf of the fund. That was my first job.
And then eventually did that switch over to the other side?
Then I got a job on the other side as a plaintiff attorney. I went to work for a small plaintiff law firm in Detroit, and they gave me like 300 files to work on with very little supervision. I just tried to figure out what to do on my own. I tried a lot of cases there, worked there 3.5 years, and handled hundreds and hundreds of cases, many trials back then, with no supervision at all. The boss did not go to court with me. I just learned it on my own. I'd also worked before that for a while for the Wayne County Prosecuting Attorney Office. So I had many trials already under my belt when I went to work for that firm. And so I worked there for 3.5 years. Then I went to work for Bob Zeff, who was a plaintiff personal injury attorney here in Detroit. I worked there for 10 years. And also, interestingly, there also I had very little supervision. I was pretty much on my own. They gave me a big caseload, and I settled and tried hundreds of cases during those 10 years. And then from there, I went to another law firm where I did medical malpractice cases for 6 years. That's all I did there, basically, every day, on behalf of the plaintiff, the patient, in doctors and hospitals for medical malpractice injuries. And then from there, in 1996, I went on my own, for my own law firm. And I've been doing that ever since.
All right, so I guess if we had to put a number, you think you're over 1,000 trials right now in your career?
I can't say that. I really don't have any idea.
Well, definitely in the hundreds, right?
For sure. Yeah.
You've tried hundreds of cases in your career.
Yes.
Also,
I want to point out that at the Zeff law firm, it was a wide variety of injury cases, including dram shop cases and product liability cases, malpractice cases, construction site accidents, and many auto accidents as well.
Right. Okay. We're going to get into the dram shop, and we're going to also get into the civil lawsuit that's been filed, which I spoke to you very generally about. And just so everybody should know here, my father, Counsel, has not really been following the Karen Reed case so closely. He knows that I have a channel. He's occasionally will watch a video of mine because he's my father. But this is really a very, very fresh perspective from someone who is extremely experienced in civil litigation. So I think everyone's going to really appreciate it. He can't be labeled one way or the other. Really, he's and you know, Father Counsel, you're not aware of this, but within the Karen Reed world, you very quickly get put into one box or the other. So I'm probably in one box already, even though I claim, I'm completely objective. I think I am, but you're going to be really fresh here. So I think everyone's going to appreciate your perspective here. But before we get into the Karen Reed stuff, just because I got Solomon here and because you said that you had a lot of trial experience, why don't you tell everybody what you think about whether Solomon's a good trial lawyer?
Oh, well, he's one of the best. I've watched him throughout his career, and he is absolutely unintimidated by anybody. He's fearless, and that's a very important skill. And he's very bright and very quick on his feet. He's got all the really, and he's also has excellent communication skills so that he can connect with jurors and judges and witnesses. So he's got really all the qualities that a successful trial lawyer needs to be successful. Yeah.
So you would say that you and I really trained him well.
Right. He's very trained well, and a lot of it just is from his hard work and also his personality. he's fortunately a very likable person. He has lots of friends. He does lots of favors. He helps the community. He's on Hatzalah. He's on the city council. He does a lot of pro bono work. People like him. People respect his judgment. And a lot of it is really self-taught. I can take a little credit, but most of his success is due to his hard work and his personality, I think.
Yeah, well, I will say, and I'll let Solomon pipe in for a moment before we get into the Karen Reed civil case, but I will say that obviously growing up in our house and being able to accompany you with all of your depositions and court appearances and discussing all of your cases, that really prepared both of us very, very well for the whole litigation world and how to be effective in that world. I mean, I think you do deserve a lot more credit than you're giving yourself. What do you think, Solomon?
Yeah, I think so too. At least I have an endorsement of my father and my brother. I guess that's a good thing. If Father Counsel would have gotten up here and said, I mean, this guy, this Solomon, he doesn't know what the hell he's doing in the courtroom. Every time he opens his mouth, I just hide my face in shame. That would really be quite an indictment. But getting an endorsement from my father is definitely nice. And I know you know this, but Father Counsel and I try cases together all the time. We've tried several cases together this year. We feed off of each other quite well. We have different skills and different approaches in the courtroom, and we definitely complement each other well, and we serve our clients well in that capacity. So It's always fun to do that.
And when all three of us are able to try a case together, that's just the best, So that's
We've
a lot
done
of
that
fun.
too.
We've done
it
it
a number of years back. The three of us got the 9th largest jury verdict in the state of Michigan.
Yeah,
I think that's what it was.
That was good. Okay, so let's jump into it because I think everyone's waiting for this. So, Father Counsel, here's the question. Let's first talk about the dram shop claim. Because that's the easiest one to discuss. Karen Reed we're going to get into the details, but we're going to get to the details of the car accident or the alleged car accident later. But first, what I really want to just concentrate on the dram shop, because Father Counsel, you've handled dram shop before, as you've mentioned, right?
Sure.
And what does dram shop really, what really opens the door to even begin discussing a dram shop action?
So in Michigan here, I'm familiar with the law here. I'm not sure if the law in Massachusetts is the same. It probably is similar, but here we have to prove that the defendant, that is the person we're suing, was in order to hold the bar responsible for the accident, for the injuries, we have to prove that the bar served the defendant, driver, or whoever, assailant, the person that caused the injury. We have to prove that the bar served that person while he was visibly intoxicated. And as a result of that, he caused the injury.
Okay, so let's talk about visibly intoxicated, right? So there's obviously factually intoxicated, where you can get a toxicologist to talk about, what the blood alcohol level was. But then there's the visibly intoxicated, which you just stressed. And that is that the person has to be visibly. So there has to be some sort of objective way that this person is acting drunk, right? So slurring their words, unsteady on their feet, all over the place. I don't know, just something that's visible, right? And in this specific case, let me share some of the evidence that came out in this case so far. We've got videos in the specific bars that are being sued. There's video footage, and the defendant here, which is being sued, Karen Reed, from all the videos, she's sitting normally, having regular conversations. She's not falling off her feet. She's not unsteady. From the people that were at the bar, their testimony was that she seemed completely fine. The last person talking to her, who just testified in this previous trial, said that she was completely aware of she was cognizant. She was, they were having a conversation for close to an hour, and they were having a regular, normal conversation. That was the last witness who spoke to her. So that being the case, do you see any sort of merit or any sort of argument even that there should be a dram shop action that is pursuable, that shouldn't get dismissed on a motion for summary disposition or a motion to dismiss.
Well, what the plaintiff attorney could do in this case is hire a toxicologist, have him evaluate the blood alcohol, and the toxicologist could conclude conceivably that based on the amount of blood alcohol in Karen's body, it's likely that she did show signs of visible intoxication. Now, that would be contrary to all the witnesses that you just cited, but that wouldn't stop the plaintiff from presenting such evidence. The plaintiff could present a showing that it's likely, based on the science, that Karen showed signs of visible intoxication. And so therefore, they may be able to make out a prima facie showing of dram shop liability. I'm not saying it's strong, but they may be able to make out a strong enough case to present it to a jury.
Okay, so essentially what you're saying, let me just break it down for the audience. What you're saying is that they will be able, perhaps, if they get a toxicologist, to be able to testify that she had a certain level of alcohol in her blood, and therefore it would be reasonable that someone, a normal person, who has that type of that much blood content in their alcohol, would generally show signs of intoxication, even despite there being all this evidence that she was not visibly intoxicated at the time. They would still be able to get over the motion to dismiss, which just means that they would be able to present their case to a jury. And so now let me ask you your opinion about this. If you've got a toxicologist on one side who's simply just saying what her blood alcohol content was, and on the other side, you've got all these witnesses and this evidence, this video footage and all the evidence, all the testimony that was there, saying that she was not visibly intoxicated, what do you think the chances are for the plaintiff to get some sort of verdict against the bars?
Well, predicting jury verdicts is, as you know, from your experience, and Solomon, your experience, is one of the most difficult things a lawyer can do, to predict what a jury will do. I mean, that's why 98% of civil cases get settled without a trial, because nobody really knows what a jury's going to do. A jury, you can have a very strong case, and a jury can vote against you. And you can have a very weak case, and the jury can vote with you. So
let me ask the question differently then.
Yeah.
Let me ask the question differently. Would you be comfortable representing the plaintiff in this type of case where all you've got is a toxicologist who says what her blood alcohol content was, and you're going up against all of the witnesses and the video footage, which clearly show that she's not acting visibly intoxicated?
No, if there's video footage showing her stone sober, I would never take such a case. And on top of that, if you have eyewitness testimony that says she was sober, I would not take such a case. No.
Okay. So I didn't think so.
It doesn't mean that the plaintiff attorney in this case will not pursue it if he has an expert witness who says that she probably was visibly intoxicated.
Okay, so you're saying that
it's actually more than that, and let me just add something in here. It's virtually impossible to prove that an accident happened here.
Yeah, but
okay.
Yeah, we're going to get there. I just wanted to get this part out first. The fact that even opening up the door before you even get to the accident, you have to first show visibly intoxicated. That she was visibly intoxicated, which I think is very, very difficult to do in this case. And and Father Counsel is saying that he wouldn't even take such a case, right? In dram shop.
Right.
Okay, let's move on to the next part. The next question here, and if anybody has some questions, you can start putting them in the chat now while Father Counsel's here, because he's going to be checking out in another 10-15 minutes, and we're going to be bringing on Mark. And I'm not sure how much more Solomon has left here. But,
when is Mark going to be here?
Mark's going to be around 11:45. We'll see how
I'll tell you, I'd really love to meet him. Let me just kind of give you a quick update on what's going on. My daughter is spearheading an event today with a friend of hers They're honoring a friend of theirs who passed away when she was 9 years old from cancer. They're spearheading an event today where a whole bunch of girls and women are going to donate their hair to an organization that makes wigs for girls with cancer. And last year we had 22 girls and women sign up. This year we have 31 who have signed up. And that event, of course, is going to be early this afternoon. And that's why I'm going to have to fly out of here in a little bit and go. But I'd really love to meet Mark if possible. So you said 11:45. Did I hear that right?
So, I mean, 11:45. Yeah, I mean, that's what I told him to. We're going to be bringing him on. But I really want to finish with Father Counsel first. So,
okay.
Because can't have too many people on the same show, but at the same time. But anyway, so fine. So now let's move on to the car accident. So there's a wrongful death, and then there's the dram shop. The dram shop I kind of spoke about. I don't think there's really much merit there. You're saying that they may defeat the motion to dismiss and get it to the jury if you have a toxicologist or some sort of expert that's going to say what her blood alcohol level was at the time. Okay, but once they actually get to the jury, again, juries can do anything, but reasonably speaking, it would be hard to imagine that they're going to win such a case when you've got all of the evidence and all the testimony and all the video footage showing that she was not visibly intoxicated. Let's move on to the accidents. Now, there's a wrongful death that was also filed against Karen Reed. Now, you know that sometimes in criminal cases, the defendant will be acquitted. It's a very high bar beyond a reasonable doubt. And in a civil case, when you're suing for money damages, it's all about preponderance of the evidence, as you know very well. So the bar is significantly lower. The standard is, the burden of proof is significantly lower. So let me give some of the facts to you about this case, because I know that you're not as familiar with the case. I'm going to try to be as fair as I can to both sides. I'm going to lay it out in front of you, and then you can give me your thoughts about this case, and whether maybe you'd even take such a case if this case came to you, knowing everything that you know. Okay?
Sure.
Sounds good?
Sure.
Okay. All right. So this is some of the major pieces of evidence in favor of the plaintiff. Okay. So number one, Karen Reed has a broken taillight. There are pieces of taillight that are located around the body where John O'Keefe's body was found. Okay. On the front yard of this house, 34 Fairview. And that, by all accounts, was the last place that he was before he was killed. So he was located on the lawn. There's some pieces of taillight littered around the yard as well as the street. There's also a broken drinking glass, which he was holding at the time that he left the car, and he left the bar holding a drinking glass. And that glass was broken, and that was also located near his body. Okay? There was a piece of his hair that was located on the back around, or near the back bumper, near the taillight area of Karen Reed's Lexus. Now, they were boyfriend and girlfriend, so he's around the car a lot, but that is a piece of hair that was found that has his DNA on this piece of hair, which is on his back bumper. There are some witnesses, and again, there's questions about credibility, but I can't go into the entire case. I just want to kind of lay it out from 30,000 feet. There are some witnesses who've said that Karen Reed said at the time when she discovered John O'Keefe's body and that he was either dying or dead, in a hysterical state, saying, "I hit him, I hit him, I hit him." So when she was asked by one of the first responders, one of the paramedics, he asked what happened, or he asked, "Do you know him?" And her response was, according to him, "I hit him, I hit him, I hit him." But she was also hysterical. But that is what she said, according to him, and according to one other paramedic, and also Jennifer McCabe. Okay, so there's three witnesses that say that that's what she said. Now, these statements of "I hit him, I hit him, I hit him" never made it to any sort of police report. Is never documented anywhere that she said these statements. And it was a chaotic scene, but these people did testify. Again, we're trying to be as fair as we can. These people did testify that that's what she said. "I hit him, I hit him, I hit him." Most of the other reports are she was questioning, did I hit him? Could I have hit him? Maybe I hit him. Is it possible I hit him? Those type of questions. But again, those are those three people testified. Now, there's also text stream data. Text stream data, which is like a black box inside of a car. And that data shows that her car, around that time, around the last time that Karen Reed was with John O'Keefe, the text stream data shows that the car was thrown into reverse and traveled around 80, 90 feet. Let's just call it that. Between 80 and 90 feet backwards, getting up to speeds of about 24 miles per hour. Now, there's also some phone data and location data, which put John O'Keefe at the scene or around the scene of where he was located. And the battery temperature on the phone consistently was going down after he left the car. Okay. And again, this is 30,000 feet. I know everyone in the chat is probably trying to scream at me and try to say that I should be, saying all the qualifiers and problems with this evidence, but I'm trying to present it as even as possible. Okay. Now, there's also people in the house who were in the house that night who testified that he never came in the house. John O'Keefe never came in the house. Okay. Those are all the pieces of evidence that point in the favor of the plaintiff in this wrongful death lawsuit. Okay. Those are probably most of them. The defense has a few extremely powerful experts. Okay. Two of them are medical doctors. And the very big problem with this case for the defense, for the plaintiff, is that the only injuries that John O'Keefe has on his body are some superficial abrasions, not to be confused with lacerations, superficial abrasions on his arm. Very, very light.
Hey, Martin, why don't you show the picture to Father Counsel of the arm and just ask him, what does this look like? And then if you want, you can even give him two options, option A or option B. Just a thought.
Let me see if I can pull it up really quickly and then show it
It'd
to
be a
him.
fun exercise.
Okay. Okay, in the meantime, if someone could just email me the picture or something. I mean, I'm just having like online. I just can't pull it up at like a big.
I'll see if I can
big
find
picture of it. Okay, so you got these superficial abrasions on his arm, and there is some major trauma to the back of his head, a occipital scroll fracture in the back of his head, which everybody agrees did not come from the car. Everybody agrees that fracture to the back of his head was caused by him falling backwards on some sort of surface. The defense will say he fell down on a raised surface, and according to the plaintiffs in this case, it'll be that he even fell down on the ground, not even on a smooth surface. Okay, but that's going to be a disputed point. But the problem here is that there's no fractures, there's no lower extremity injuries, there's no contusions, bruising, there's no torn tendons or ligaments on his arm, which is the only place conceivably that he got hit by this car. So and also, quite frankly, the arm looks like it was bit by a dog.
Hey, you just gave it away. I just sent you the picture, by the way.
In my email?
Yeah. Your Radner Law Group email.
Okay.
And let me just throw a little context in here now that you kind of mentioned that. So, Father Counsel, basically, there's two possible options for how these injuries got to this arm. One is blunt force trauma by being hit by a vehicle, a Lexus SUV, and then caused by the taillight. The other one is by a German Shepherd known to have aggressive tendencies. Those are the two options. Now, when you see this picture, let's see if you think it's as obvious as I thought it was. I know you won't lose your objectivity just because you heard what we had to say about this. But again, the two options are, number one, the arm got hit, with a sweatshirt on. So this guy, he's wearing a sweatshirt. John is wearing a sweatshirt, and then his arm gets hit with a vehicle, and then the taillight pierces his skin in this way. Alternatively, it's a dog bite. Martin, are you able to pull the picture up? Here we go.
Dog bite.
Now, if an expert would try to convince a jury, this is what I said, and I'm curious what you think about this. If an expert would try to convince a jury that this was done by a car blunt force trauma and the tail light piercing the skin, I said that that's as offensive as trying to bring a NASA scientist to say that the earth is flat. The jury knows right off the bat what that is. They don't need to be told by an expert what it is. It's obvious what it is. And if you convince them otherwise, all you're doing is insulting them. Would you agree that it's that obvious or not so much?
Yeah, I agree with you. However, if I can just offer my thought, the plaintiff in this case could come up with this theory that when the decedent saw the vehicle being put into reverse, heading in his direction, he tried to get away and he slipped. Since it's snowy or icy, he slipped on the pavement and fell down and cracked his head on the concrete or whatever he fell on. So he could have been killed in this accident without his arm being hit by the car.
Right, except so that's a possibility. Is there any way for them to prove that?
Oh yeah, there is a way they can prove that. It's called through an expert witness. They could hire a accident reconstructionist, and he looks at all the information and he comes up with that theory.
So let me ask you something. You and I had a case recently where it was determined at trial that the expert received $40,000, and we used that to attack his credibility. Martin, why don't we tell Father Counsel how much the experts got paid by the Commonwealth in this case? And you tell me if this is an amount that you think might possibly, in a way, perhaps some way or another, affect their credibility.
Well, the contract was allowed for up to $400,000.
$400,000
for one expert?
For two experts.
Two experts?
Yeah, from one company.
Hmm.
And also, Father Counsel, you should know that this accident reconstructionist that they hired did not come up with that theory that you had. I mean, maybe if he was being coached by you, he would have came up with that theory. But here, they tried to figure out a way that those injuries to his arm line up with the car. Because how are you going to explain those injuries to his arm? If there's no interaction between the car and his arm, how did he get those scratches on his arm?
Well, the defense claimed that he was bit by a dog, didn't they?
Well, the defense
inside the house. The prosecutor said he never made it into the house. It's a real problem. Prosecution's case never made any sense.
Mm-hmm.
It never made any sense. And at one point, the defense actually, during one of their motions, they argued to the judge, "Your Honor, the prosecution has no case."
Mm-hmm.
And he was 100% right.
So according to the prosecution's own theory, he could not have been bit by a dog.
Right.
Unless the dog was outside.
Which there's no evidence of. Why would the dog be outside in the middle of the night?
Perhaps.
Right, well, we don't know apparently nobody knows where the dog was. I mean, the dog could have been anywhere.
I wonder that Karen was acquitted, because that's a really weak argument on the.
And I didn't get to this part. There's the defense did hire accident reconstructionists, and they did real reconstruction. And we're not going to get into what the Commonwealth's reconstructionist did, because he didn't do anything that looks like a reconstruction at all. It was laughable. But the defense experts actually did reconstruction, and this reconstruction, they showed that it simply does not work with science and physics, that her car hit John O'Keefe and caused those injuries. The damage to the vehicle and the injuries are not consistent with one another for that interaction ever happening. So again, well, let's just use this theory, because this is the theory that was put forth, and this most likely is the theory, not your theory, but the theory that the plaintiff is going to use in their case, in the civil case, that she actually backed her car up to and hit John O'Keefe. So when you've got these two medical doctors who say it's not consistent with being hit by a car, and you've got these two biomechanical engineers, ARCA accident reconstructionists, saying it doesn't, and they actually did a reconstruction, saying that nothing's consistent with him being hit by a car. What would you think the plaintiff's chances are, even the bar being lower than beyond a reasonable doubt?
Oh, based on that presentation, very, very low probability. But I think that the
Would you
plaintiff
take this case?
attorney, but the plaintiff attorney would be well advised to explore other theories of liability, not the one that was rejected by the jury in this case for obvious reasons.
So what if they would call you for your advice? You would say you got to get a new accident reconstructionist and try to figure out a whole different theory of how this accident could have happened, because whatever you're trying in the criminal case is definitely not going to work, even in the civil case.
Yeah. I mean, what happens in the real world is that the attorney has a theory, and he shops around, and he sees if an expert will subscribe to his theory. You just don't dump all the evidence on the expert and say, what do you think? In a case like this, I can assure you the plaintiff attorney is going to have a theory and is going to ask the expert witness, do you agree with this theory? Is it feasible? And by the time he gets retained and is paid God knows how much money, the theory is going to turn into an opinion. That's what always happens. The theory, which is just like the theory of evolution, no evidence, just a theory that people believe in. The theory eventually becomes an opinion. And then the expert starts looking for evidence to justify his opinion, which at the end of the day is nothing more than just a theory without any evidence, or with very, very, very little or very weak evidence. But you'll see they'll come up with somebody that will subscribe to a theory that will be different than what the prosecution presented to this jury.
Okay, that's very interesting. So your call is that they're going to come up with a whole different theory and present that to this jury in the civil case.
I think that would be very wise for them to do that. I'm not giving them advice, but the theory that you presented to me from the prosecution is so ridiculous that I don't see why any intelligent attorney would want to present that to a jury.
Even in a civil case.
Even in a civil case.
All right. I think people are seeing where Solomon gets his feistiness from. But before you leave, Father Counsel, I just want to pull up a few chats here, and then we'll bring on Mark. Poetic Justice, who's a big fan of the channel, is always a big supporter. Now we know where these two men get their grace, charm, brains, and eloquence from. This has warmed my heart. And then we have this here from Make It Make Sense. Happy belated Father's Day to Papa Radner. And actually, that is what we used to call Father Counsel's father. Our grandfather, we used to call him Papa. So, okay. Well, Father Counsel, thank you so much for joining us and giving your thoughts about the civil litigation and your thoughts about whether the prosecution's theory in this case would have any sort of weight or chance if they present that theory. Your only suggestion would be to the plaintiff attorneys that they better come up with some other theory and try to sell some expert on it and pay him enough money to say that theory is actually what happened, and then try to work that on a jury. So, okay, that's good to know. So thank you so much for joining us, and we'll see you next time.
It's been a pleasure being on your show, and I wish good health to all the people who are watching and listening to your show as well.
All right. Thank you. Oh, also, if there's someone who's injured in Michigan, how in the world should they get a hold of you and get the best attorney in Michigan to handle their case?
888-I-SUE-BIG.
888-I-SUE-BIG. If you want the best plaintiff attorney in Michigan by far. And by the way, just so you should know, if you're in Michigan and you see all these ads being thrown at you every day by some of these big firms, if you call those firms, you're going to get some young associate to work on your case. You'll be lucky if one of the senior associates or partners even looks at the case once a month. But with Father Counsel, you get the entire Father Counsel for the entire case. He's working on the case from day one. He's drafting the complaint. He's working on the discovery. He's working on the depositions. He's taking the depositions. He's going to facilitation, which is why when the defense attorneys see Father Counsel on that pleading, the value of the case skyrockets because they know they're going to be dealing with my father the entire time, not some young associate who they can have fun with. So if you're in Michigan, the only place to call is 1-888-I-SUE-BIG for Father Counsel. All right. Thank you very much. We'll
Thank
see you
you.
next time.
Thank you very much, guys.
Bye. All right, guys. Well, I don't know how much longer Solomon has, but without any further ado, let's bring on. And you are muted, Solomon. Now you're not. Oh, now you're not. Now you're not. Now we can bring on Mr. Bederow, my brother Grifter.
How are you? Nice to meet you, Solomon.
Nice to meet you, Mark. I've heard a lot about you. I've seen a lot about you, and it's really an honor and a pleasure to finally make your acquaintance.
I'm glad I overdressed again today. I was told there'd be a Tigers fan somewhere in here, and so I thought I would needle somebody with my Red Sox stuff, and we get suits and Sunday wear.
I was going to make a comment about that Fenway. I'm sure you remember the 2014 ALCS game with Big Poppy's grand slam, which basically knocked the Tigers out.
2013, I know only because they won the World Series, and yeah, Torrey Hunter going upside down, and the fat bullpen cop, absolutely.
Yep. Still painful.
Yeah, we remember that well.
Well, Mark, I'm just wondering who you root for now, because I mean, I don't think you're too excited about Boston Red Sox. So, like,
actually, they're in a playoff spot right now. They're not very good. I will grant you that, but they're not bad. They're just kind of okay.
Well, I mean, if you want, you can always start rooting for the Tigers and Scooble.
I believe the 1984, right, is the last time. Willie Hernandez, that crew. But
yeah,
I'm dating myself. When I was
thanks for rubbing that in 41 years ago.
Yeah,
really? I thought they won in like the 2000s with Verlander once. Didn't they win once?
Made it twice and got destroyed twice.
Oh gosh.
Okay. The 84 team. I mean, I'm a big baseball kid growing up. I mean, they had Kirk Gibson, Lou Whitaker, Alan Trammell, Lance Parrish with the orange glove. I remember Jack Morris, Dan Petrie. Right? Wasn't he there? Like kind of.
Yeah, he was. They were a special.
Yeah.
Listen, Mark, I don't know if you heard this or not, but my daughter is hosting a beautiful charity event today. So I got to fly. She's hosting an event where a whole bunch of girls, 30 girls and women, are going to be donating their hair to a charity in honor of a friend that passed away when she was 9. So I got to fly. I got to go help her set up and take care of things. It's an honor and a pleasure to meet with you. I'd love to talk to you more about this case and other cases any other time, but today's not the day.
Yeah, go do better things. That's noble stuff.
Take care, Martin. Take care, Mark.
Okay.
Thank you both.
Thank you. All right. Well, I mean, Mark, if it'll make you feel better, I'll loosen my tie a little bit and loosen my top button, if that'll make you feel better.
No, I don't care. Hey, if you can do that on a Sunday, wow, I'm impressed.
Yeah, the truth is I really don't have any other clothes. I just have suits. So
I don't have much in between. I have suits and slob. I don't really have. I need to bridge that gap a little better.
Well, okay, so let me start off with, we've got this verdict now, obviously, and some of the jurors are coming out. And we'll talk a little bit more about some of the reaction of the jurors. We'll talk about that a little bit later. But the first thing I think I want to talk to you about, because I know people have been asking me, and people are getting nervous about this, and definitely from the other side, they're trying to cook up ways to somehow overturn this verdict. We've heard about that, in the last trial where after the last trial, they thought that they really had a verdict on charge 1 and charge 3. So bring the jury back. Maybe we'll ask more questions. So let me ask you a question, Mark, and just, wide open. Let's say we find out that one of the jurors violated the instructions, was going on social media, was watching Brother Counsel and Mark Bederow. And that's probably, if I'd imagine, what the anti-free, care, and rape people are doing now. They're trying to probably dig into all these people and try to find somewhere, some cousin's boyfriend's dog who was doing something. And then they can say, see, this person violated the rules. Let's bring them all back, mistrial, have a new trial. So I think people are nervous about this legitimately. And what's your take on that specific scenario? And we'll talk about some other scenarios in a minute.
Well, there's nothing to be nervous about. Consult real lawyers, not Twitter lawyers. An acquittal is an acquittal is an acquittal, and double jeopardy is a real thing. The trial's over. Even if it turned out that some juror, which I don't believe will be the case, and you see what's going on, with the treatment of some of these jurors. But even if it were to turn out that some juror got themselves on the jury with a bias or violated the rules and whatnot, well, then you would be looking at issues perhaps with the juror personally, whether even potentially criminally, which again, this is a hypothetical. I don't think this is the case, but a jury verdict in favor of a criminal defendant is sacrosanct no matter what. It's over. The criminal case against Karen Read, stemming from what happened or didn't happen in January 2022, is over unequivocally, permanently, full stop. That's it. Done. Finito.
Well, let me just play devil's advocate for a moment, because we know if, let's say, there's jury tampering, so like what happened with Murdoch, and I think that's at a real risk for getting reversed on appeal, and he's going to have another trial. That's what I think.
But that was a conviction.
That was a conviction. But so let's flip it the other way. Let's say let's just go crazy. Karen Read is this narcissistic nutcase who got someone to track down one of the jurors and was feeding them information and manipulating this specific juror, and that's what this juror brought into the deliberations. And now
then you indict again. This is such, in my view, a ridiculous hypothetical, but I get it. Then you investigate and indict whoever's responsible for jury tampering, which could include the defendant who was acquitted and the juror who was involved in taking bribes or doing things they weren't supposed to do. But the murder case is over. But if there's future crimes that are unrelated to those indictments that surround the trial, then you could bring criminal charges for fixing a jury. I mean, that's happened. It's not common, but it's happened. But, in terms of January 2022, done.
So what you're saying, and with the Alex Murdoch case, you would say, well, that was a conviction. So a conviction is different, when you allegations of jury tampering as opposed to an acquittal.
Yeah, in that case, it would be Murdoch who says, I'm finding evidence of shenanigans involving the jury, and that violated my right to a fair trial. So I should have a new trial, and off they go if you could prove any of that on appeal. But, it's never, obviously the defense would not appeal this. She got acquitted on anything that matters. And you're interested in hearing this? All right. And that's
everybody loves Brother Counsel.
And Lola's a big fan. Yeah. Such a big fan. She's curled up in a ball on my feet. But it's over. I mean, the prosecution can't do anything. In fact, the only thing the prosecution should be doing now, to the extent it relates to this case, is monitoring and seeing a lot of this disturbing behavior that you're seeing online, where jurors are just under full attack by delusional lunatics online.
Yeah, we'll talk about that soon. Let me just throw another hypothetical, because this is also being floated around, and I understand. I mean, I don't understand these people, but I get why people are getting nervous about these type of allegations. And then, so let's say you have a juror who wasn't a citizen. I saw that idea being floated around, and they're probably looking into the citizenship of some of these jurors. You think that would have any effect on? Okay, well, that's not fair. We gotta, maybe either call an alternate back and redo the deliberations, or what do you think about that?
No, again, it's double jeopardy. It's over. If a juror lied during jury selection, which again, I don't believe is the case, but if a juror, jurors, when they're questioned, they're sworn. There's a reason why they're sworn when they do these things. The idea is they'll tell the truth. But if a juror lied to get on the jury and lied about being a citizen, and that came to light, then the juror could be facing perjury problems and other legal situations of their own. But that's not going to impact the verdict that let Karen go.
Right. So I think everyone should just kind of calm down, and all this noise on the other side is just noise from people who have such a deep, deep hatred for Karen Read, and have no respect for the judicial process. So
are you seeing this online? Like, I need this. This is such crazy town talk. I need to see that. That's unbelievable.
So I've seen a little bit, but I mean, it's funny because, once we had the verdict, and obviously there's going to be, people on both sides, and we'll talk a little bit more, I guess, about Proctor and some of the Alberts and McCabe's interview in a minute. But, I just figured, okay, I want to go crazy for a day or two, and then we're going to move on. Life's going to move on. Everyone's going to go back to normal. We'll move on to the Koberger case or Sandra Birchmore or whatever it is. And it just seems like people just can't let go at all. And there seems like even this outrage and some craziness, which you're talking about. And I don't even know so much specifics. Maybe you know more than I. Maybe you can share the jurors that are being harassed. I mean, what do you know about that? Has that come to your door? Like, well, what's going on with that?
Well, it's all over Twitter. I mean, you see it. There's one juror they're claiming is not a citizen. There's been some vitriolic racist attacks because she's, comes from another country, came here, speaks with English with an accent that somehow makes her unqualified. And she's been called horrible names. I'm not sure if other jurors have also been called terrible things. Some people have been tweeting saying, wouldn't it be funny if you ended up dead and that would be karma? I mean, these are just certain examples. And the irony is, I have a lot of experience in Massachusetts witness intimidation, as you know, and that statute covers jurors, and it covers jurors who are retaliated against and are either intentionally or recklessly, with some impeding the administration of justice, all of that language, in a way that can be upsetting and whatnot. And imagine just being a juror, you get called by the press and they say, will you speak? And you say, okay. And then you very rationally explain, which you don't have to do, but in this case, a lot of jurors, it looks like, have chosen to do it. They explain what their thought process was, pretty rational. And because a certain segment of the population doesn't agree with it, they just go crazy town over this. And they're going absolutely bonkers. And they're claiming that, this juror was a plant because after the trial, as I think is very common in a high profile trial, the jurors who have not been following it are subjected to any of the attention. Once it's over, it's pretty normal to look online and see, what are they saying? And they do that. And then they start following people. And then they start following, brilliant people like, the two of us and others, and are interested in what we have to say. And then naturally it means, oh my God, because we have a certain view of the case. I've always thought Karen never should have been prosecuted, let alone tried twice, not once. And, you obviously have an educated view that favors, a not guilty finding here. And the juror follows people that think like that. And it spins into, she's been watching the case from day one and listening to this. And, she should be reported, should be arrested. They're going to subpoena her Twitter account. I mean, people need to move on with their lives. And most of these people have nothing to do with the case anyway, other than just watching it from afar, which is what's really, really bizarre about it. It's just a lot of keyboard warriors, on the couch. You just can't leave it alone after the fact. I mean, the jury deliberated, they voted. This happens every day in America, and it's over.
I think we may need some more letteros by Bederow about this intimidation, to the Massachusetts State Police, whoever's necessary.
If called upon to serve, that, perhaps I would. But I mean, the point is, it's just absolutely crazy. And, it's triggering to a lot of them too, because I did ask last night in a kind of rhetorical question to the Massachusetts State Police in a tweet saying, does this count as witness intimidation as much as, I don't know, journalists who are accused of saying things to witnesses? And it would seem to me that if, rubber duckies around town is witness intimidation, coming hard after jurors might as well. And, you can imagine how that went with certain segments of Twitter.
Let me show you something. This is something I just did a video on. I don't know if you saw my videos or not, but it's something that caught my attention because I thought it was so egregious. And you know me, Mark, I'm very careful with my candor to the tribunal when I'm talking about a judge. I always want to be careful and weighted. And even with Judge Cannoni, people have been at my throat the entire time. Why aren't you just calling her bias and call her out? And I've said I've seen some issues. I said things I don't like, objections, rulings. But take a look at this. I don't know if you probably seen it, but I haven't gotten your reaction on it. I don't know if you've seen my reaction on it, but it's something that not just from this judge, but I'm hearing from other lawyers, which I don't know, just give me kind of your reaction on what's going on here.
Karen Reed is acquitted, which means right now no one is being held responsible for the death of
Judge
John.
Lou.
And Judge, outside of court, one of her attorneys was asked, are you calling for a reinvestigation into what really happened? You think the Commonwealth will actually reopen any type of investigation?
I don't have any inside information, and I had no communications with the folks involved in this, but certainly not. Karen Reed killed Mr. O'Keefe. They just couldn't prove it to a jury. And in America, that means you're not guilty. It does not, I repeat, it does not mean that you are innocent. She had a lot of nerve saying to that microphone that I want justice for Mr. O'Keefe. She was acquitted, but there's nobody else to investigate. There's no third-party culprit.
All right, so you heard it. I mean, I'm sure you've seen this before, but I did a video on this because I was just so taken aback. I mean, I understand there's people that hate Karen Reed, and I understand they want to spew their hatred on their YouTube channels and Twitter accounts and everything like that. But you're a judge. You are a judge. It's like
there's been some real unstable behavior by retired Judge Lou in the past several weeks.
Now, this is the first that I've seen because I don't really follow him that much. But
I mean, he's been on a few Boston shows, and he's no longer allowed on them because of this kind of thing. I don't know anything about him other than when he appeared on Twitter a couple of months ago. I actually enjoyed some interesting, very polite engagements back and forth. And then a couple of weeks later, he went into full block mode rally cause about, major witness intimidation, stockpiling files to, come after people, and which was a little disturbing. And then you start seeing, a retired judge, and that carries a lot of weight to people who maybe are not into the weeds of what people say online. And for a retired criminal judge to have anything other than respect for a jury verdict on TV, and then essentially defame the acquitted defendant, and then express outrage at what she said after, is highly, highly inappropriate. It's highly disturbing, and it almost makes me wonder if I had been a defendant before him and came in second place and thought there were some oddities, that I would be concerned. Now, some people think maybe it's old age, early onset dementia. I don't know, and I'm not going to even pretend to get into that, but those comments are, beyond inappropriate, and they discredit the network that put him on. He discredits himself. And, as a judge, for him to basically say that the jury verdict was wrong, and then to attack the now, presumed innocent again, right? They never took away that presumption of innocence from her. This acquitted woman it's terrible. What else can you say? I don't know how anyone can defend that.
Yeah, and there's that judge. And by the way, I do want to say, in full disclosure, I believe that that station took it down, and they're distancing themselves from this, that type of analysis, if you want to call it. And also, I've been on NBC 10 Boston. I think they've also had Judge Lou on. And I know they're good people, and no one should feel like they can't watch those stations anymore.
No, it's not the stations. I mean,
Yeah.
I've been on all those channels. The two channels that had really regrettable comments, I mean, I think they basically took him off the air and don't have him back. And again, it's not a personal thing on him. I don't know what happened, because as recently as a couple of months ago, I enjoyed some interaction with him. And then to see this was just stunning.
And it's the funny thing is, I mean, it's not really funny, but there's other attorneys out there. I know that you've engaged with, was it Wendy Murphy or something? And I haven't looked anything up about her. I don't know if she's legitimate or I don't even know anything about her, but she's supposed to be some sort of professor and a lawyer. And I mean, you must know more about her than I do, because you always point out certain tweets that she makes. But yeah,
she's a Duke lacrosse truther. That's all you need to know. She will die on the hill that the woman was raped by the Duke lacrosse players, and that the DA, who, as you know, went to jail for suppressing exculpatory evidence and other conduct in that case. He did 30 days in jail, Nifong, the Durham, North Carolina DA, back when that happened. Wendy Murphy will tell you to this day that it's all a fraud. She was paid off and they're guilty. She's putting up
the victim was paid off, and that's why.
She's telling the truth. The victim, by the way, the fake victim in that case, but convicted murderer at the same time. I don't know if you're aware of that. She is doing life in prison, I believe.
That's right.
For murder.
Something like that. Yeah, I mean that's.
But Wendy Murphy is also putting up other tweets, basically implying that Officer Barrows, the good cop, if you will, the one who testified about the condition of the taillight, was paid off, which is another, absolutely libelous statement she made, which John DePietro, the Baghdad Bob reporter, kind of agreed with. Wendy Murphy was putting up tweets attacking the jury and saying they should all have their citizenship stripped. I mean, really bonkers stuff. And,
is she a professor?
She was. I don't know if she is. I don't know how anyone, I don't know how anyone could employ her in a law school setting. I don't know how anyone could ever hire her as an attorney. She's a former prosecutor. She styles herself as a civil rights expert. She's the one who knows nothing about the Fifth Amendment, privilege against self-incrimination, and how people should presume guilt if you don't testify, and how, Karen took the fifth, all these kinds of things. She's just an angry, miserable, and not too bright attorney who gets a platform, by the way, on Court TV with her good friend Jennifer Coffindaffer. If you've ever heard of her,
it's funny because I don't really mind that much about Jennifer Coffindaffer, because I just feel like if you're a lawyer or if you're a judge,
it's worse. It's worse.
Yeah, and you're saying things like, what is with the cognitive dissonance in this case? Like, how is it that there's like 90% of the people that are covering this case, all the law tubers that I know of, I mean, the legitimate ones, not the ones that just popped up a few months ago with, but the ones that are actually covering this case, the ones that are looking at this case, I don't know, just people that are looking at this, most attorneys that I've spoken to about this case that don't have platforms. I just, I'm talking to lawyers all day. That's what I do. And I just, hey, let's talk about this case for a moment. And I mean, like 90% of them fall where I fall. I mean, and then you got some of these and they're lawyers. So like, what am I missing? What am I exactly missing here? That they got some sort of lawyers on their side, to support their anti-free Karen Reed stuff. And then they start tweeting things like what you've seen.
I don't know. And I mean, if they obviously lawyers, you battle and then you go to the next one, but there's finality when the jury speaks, at least pending appeals if the defense loses and that kind of thing. But this case, like you said, I've never seen anything like it. It's now, it's almost a week later, whatever it is, 4 or 5 days, and they are still just all in on going after jurors, complaining about all this corruption. And the irony is, their talking point for a lot of them, including, the lawyers like Wendy Murphy, has been this tinfoil hat conspiracy, allegedly, by the people that supported Karen, and all they do is see conspiracies, and it was a car accident and anyone can see it. And here they are now because a second jury, like the first jury, no one convicted her of anything. I mean, the misdemeanor DWI, I mean, nobody cares about. I'm talking about the indicted charges, obviously. And now there's some kind of conspiracy where people are, lied to get on the jury and this. But the part they leave out also is, the one juror who they're in particular going after, and they're going after her because she's the one speaking to the press. I mean, they would go after anyone else, but this one juror must be so brilliant because by being the corrupt person that she is, she has incredible persuasive abilities, or at least can use like Jedi mind tricks on the other 11 jurors to get them all to fall in line and say, well, yeah, these aren't the droids you're looking for, right? These aren't the droids you're looking for. So she's not guilty. Karen Reed is not guilty. Karen Reed is not guilty. It's crazy. And if you saw some of the interviews with the other jurors, there was one juror in particular, maybe an older woman, not old, but older than this juror, who said, I went in when we started deliberations. I thought she was guilty. And then,
I thought it was the same one. I thought it was the same one that's coming out now getting attacked. One that she initially thought it was manslaughter. That was somebody else.
No, I'm talking about someone else, kind of just a different, I mean, I don't want to call her old. She's not that old, but maybe 50, compared to the other juror, I think it's a little younger. And she just basically, the other interview, the juror said, I thought she was guilty when I went in there, but we talked through it. And, there's reasonable doubt. So she was more like a reasonable doubt juror, where the outspoken juror is, I believe she's innocent. Like I'm going that extra level. Another juror, a male juror, who I think was the first one to speak, came out and said, I think she's innocent. And they came after him. They started accusing him of being either mentally ill or autistic and didn't understand. I mean, just crazy stuff that you're seeing coming after them for having the temerity to having heard the evidence without the outside influence and saying, like, by the way, as the majority people believe, she's not guilty. It's really not that controversial. It's pretty basic, actually.
Yeah. I mean, it's just it's sad to see. Like you said, it's really sad. So let me ask you another question. Did you see the Alessi and Iannetti interview?
I did.
Okay, so I know it was like 5 hours, and
it was long. I got Ian though. That I've been there, and it's
like Ian. Joe Rogan. It's like, you're gonna go for hours. But I mean, I was a little surprised, but they hung in there. I mean, after sitting through a 31-day trial, I guess 5 hours is like, what's 5 hours? Yeah. But I started seeing it last night. I got probably an hour and a half in, an hour and 40 minutes in. Did you pick up anything is there anything that stuck out in your mind, like that was interesting, or some new information or strategy or things that we've been talking about over the past month or 2 months that,
it's interesting. I mean, I know some things that other people may not know. I mean, I was around these people, for a period of time until, the judge wouldn't allow me. So, I mean, I kind of have perhaps a different lens in looking at it than others, but I don't know anything that's happened in the last several months. So, but I just thought the takeaway that I had was something that I've always said, and that one of the reasons why the defense was always going to win the case, and on top of having, facts on their side, was look at how good these lawyers are. Look at how honorable they are in the way they practice, the way they communicate, how organized they are. And what occurred, and this has always been my thought, the DA in this case was just so overmatched and outgunned legally. Okay, you had one lawyer essentially trying the case against 4 high-level lawyers. You had, in my view, very ethical, likable, hardworking defense attorneys versus one not so likable, questionable ethics that you saw during the trial. Very hardworking, very intelligent, very skilled. But to me, what just came out was that's who these guys are. They're good guys, they're hard workers, and they were motivated by their belief that their client was innocent, not just, because we're lawyers and, you represent a client. And of course you do, but let's be honest, it's a lot when you think you have an innocent client. I mean, that's going to weigh on you. And I don't know, you could just see it, and you could see how relaxed they finally looked. You can see the emotional outcome after the verdict. But as far as the takeaway, I think there's things that people see. When they're not answering questions about, the garage and the photographs which surfaced online of the garage. You can draw your own conclusions on what maybe they wanted to say, but couldn't.
And, I was wondering, so there's a few things that I saw. Again, I didn't see the entire interview, but I saw probably the first hour and 40 minutes. But number one, when they were asked about Proctor, whether they're going to call Proctor or not, they kind of punted. It's something that as an attorney, I'd really love to discuss with them in terms of strategy, what was going through their minds one way or the other. I don't know what, like he said, like he can't talk about it or something, or Leslie said he can't talk about it. Certain things I can't talk about. I don't know why.
I don't know why. That's certainly a topic that I know nothing about, because that would have been conversations long after I was not around. So I don't know why they couldn't, unless they just didn't want to share privilege in the sense of amongst each other. Maybe they were implying it was, not an agreement for some period of time until they landed where they did. I don't know. I always thought they should have called Proctor. The takeaway I got from the interview the other night with these two guys was that they came out on the side that the boogeyman theory was okay for them. And also that I think they were concerned about him somehow being sympathetic, to the extent Proctor can be sympathetic, which if you saw his interview on ABC, he can't. Which is kind of how I felt, saying, this is why I would have called him. Look at him. But I think
Mark, let me just call you off for a second, because I remember the first trial, and during the first trial, I can understand Higgins. I can understand not calling Higgins. He may come off a little bit more likable, but Proctor, in my mind, came off not likable at all. Regardless of how much he tried to explain or say, yeah, I made some mistakes, but he just didn't come off likable. I understand, so like when you're talking about, okay, should we call Higgins? Is he going to come off more likable? And look, he kind of got dragged, who was the initiator? Karen Reed kind of dragged him into this relationship, or she started with the weed whack, whatever. I can live with that. But Proctor, like I said, like with you, he's so unlikable. And, I think they would have just, and again, part of it, when I keep rethinking about this, when I'm watching these, they're talking about it and they're not really explaining much more about it. But some of me says, or some of my thoughts are, if you don't need it, why do it? And
absolutely. I think that's part of the thought. And even, when I would talk about this, when people would ask, it was always with all disclaimers. They know things we don't know. These are some of the best experienced lawyers you're going to get. And if they're not doing it, they've made a judgment for a good reason not to do it. And we can sit and agree or disagree, but we don't even have access to the full amount of information and thought process that they do. And I'm sure a major part of the why do it is the theory of, if I don't need it, I have reasonable doubt, I don't need to do it. And of course, criminal defense attorneys are normally in the business of minimizing risk, right? Like minimizing exposure, just not assuming burdens I don't need. And although I didn't agree with it from the outside, again, without knowing what they're doing on the inside, it's a perfectly rational belief and practice to say, we don't need to do this because there's so much reasonable doubt, it's too risky. And then of course they won. So, you have to, at the end of the day, it's a result oriented business, and they didn't call him. He was the boogeyman and she was acquitted. So it's tough to criticize through that lens.
Yeah. Something else I was just, while I was watching the closing, I know we haven't spoken since probably in the middle of the trial sometime, but when I was watching the closing, I thought, and I don't know if this struck you as a little bit odd, I thought that I would have really hammered much more about the fact that the Commonwealth didn't call Proctor. I know Jackson brought it up. He brought it up and he said, you probably have some questions about, when you wanted to hear some more information. But like, I thought there could have been a lot stronger saying, this may be the first criminal case ever where the lead investigator isn't called. Like, just some way to, I don't know. It just struck me as like, hey, I wonder why, like, they're kind of, Jackson didn't like do more with it, which I know that he could. So again, there's probably, I am just imagining that there's maybe some more strategy. I don't know. Like, I'd love to discuss this with them. And by the way, before you give your answer, I will say that I did reach out to Robert Alessi. I hope that I get to speak to him on the show. I'm not sure what he's going to tell me, but these type of questions are the questions I'm going to ask him. Like these type of strategy questions, which I'm thinking of as a lawyer if I was in that position. But yeah, go ahead. So tell me what.
Yeah, I mean, certainly more, I guess, could have been said about that. Again, it doesn't matter because the result is the result. I thought, though, the way they used Higgins and Proctor together, not as Higgins being an alleged killer or anything, but just as missing all of these red flags, making him a suspect, and Proctor not using him, not looking at him, not trying to do anything to even look into those allegations, I thought was handled well. Yeah, they didn't go after Proctor too much in that way. But on the other hand, I love what they did in the summation by going after Brennan. And I think that is really powerful to the jury about the hoodie incident. I mean, I think that was such a gift they got, and I thought that was great. And, I'm sure I said this to you. I've said this to people all the time. The prosecutor's credibility in a case like this is so critical. I mean, just their integrity, everything, and to spell that out for the jury about that stunt that was pulled and to call that into question with everything else, given the overarching theme of the case, that there's just this law enforcement, whether corruption's the word, misleading, whatever it is, however you want to categorize it. I thought that was very effective to use alongside the science, which ultimately was, why she got acquitted for sure.
Yeah. It's I just lost my thought, but I was just going to go on with something. I just can't believe that Brennan didn't address that in his closing. Jackson gets up there. He says, the sweatshirt, you all saw it. This is exactly what you're dealing with. And Brennan completely ignores it. He knows he made a mistake. He said to the judge he made a mistake. What do you want the jury to think now? Don't you think? I mean, like I said, if it was me, I would get up there and say, ladies and gentlemen, I made a mistake. I'm human. There's a lot of evidence in this case. You're going to see all the exhibits and everything. And I made a mistake. I thought in the back of my mind, there was some holes in the back. I made a mistake. You're right. But there's just so much going on in this case, and I got confused. I think
he didn't do it to protect himself. Okay. If you saw what happened after the mistrial application, every opportunity that he would have had in some capacity to address it, he didn't. Okay. He abandoned his rebuttal case, which I believe in large part was because of the hoodie, because of the x-rays, and frankly, even questioned, was that some form of conflict because he did it out of self-interest or interest for the prosecution as a whole? I don't know. I don't think he would have liked the answers he would have gotten from the witnesses about the holes in the hoodie and the x-rays.
No, the x-rays was just
a disaster. And he would have gotten killed on that. The charge conference, he pulled Lally out of the mothballs, had him address that. Okay. Which is a smart move. Don't make statements about it. What does he not do in the summation? He doesn't address it. He's making it more acceptable for the future for him because there's less of a record. He's not making it worse. And I think he just tried to ignore it. Now, I agree with you. How do you just take that? But he took it from Alessi during the mistrial motion. And I think the reason he took it is because I think he did it on purpose. I think it's obvious, in my view, that's my opinion, that he did it intentionally. I mean, I think, and you saw that the other night that, Bob won't say it again. I mean, he said it in court, so you might as well just say it again because he said it in court. This was intentional and outrageous. But I mean, do you see any evidence that that was an accident? And what about the other 2 potted plants sitting at the table? Do you have nothing to say, nothing to add? You've been on this case for 3 years. So I think he left it alone in summation because what do you say? How do you, and then he runs the risk of also defending his own credibility. And, do you start getting into, giving unsworn testimony and are you now, arguing and putting your credibility literally into issue, which is a no-no, as you know. I mean, it's a third rail for him. It's difficult.
Yeah, I see. I understand. I just, I like you said, in this type of case, your credibility is everything. And if you got to address it, you got to have to address it one way or the other. I think to the jury, at least to the jury, if you want to win the case.
I mean, yeah, he put himself in a terrible position and they didn't address it at all. But, the biggest way that he could have handled it was not to do it in the first place. And then you wouldn't have to address it. And you wouldn't even be discussing this now. But that whole thing came off as just an intentional stunt and it has consequences. And I think it hurt him a lot. And I think he got muted a lot. After that happened, he finished up the trial weak. His cross-examinations got, less effective. He ran out of steam a little bit. Maybe again, self-interest, self-doubt creeping in. I'm not going to do the rebuttal case I've been banging the table for weeks about. And, you listen, no lawyer wants to be accused of committing intentional misconduct in a high-profile murder trial when everyone's watching. But even when he was called out in the mistrial application, he never pushed back. Now,
he said he made a mistake.
But he never, look at his personality, okay? He's willing to go down, roll up your sleeves, and argue about using Signal, and you're a dirtbag for that. I mean, talking to credentialed doctors about using Signal and eating ham sandwiches. But your ethics get called out by your opponent, okay, in the middle of a high-profile murder trial that everyone's watching, and they basically say, you just tried to intentionally mislead the jury. He is not a shrinking violet. On that one issue, he just took it. And yes, it was an accident, but what do lawyers who are falsely accused of committing ethical transgressions in that matter do? They usually push back, if nothing else, and say, you're wrong. Okay, that is for you to say that with da-da-da-da-da. The problem is the defense appeared right.
Yeah.
And this is a guy who has no problem throwing out ethical claims without evidence himself. I know this because he did it to me. I know that. He said I gave evidence from, client A to client B, which was just not true, with no evidence and he said it. And when there was a lot of evidence that was coming after him for doing the same thing, he just kind of took it, which I think is very interesting and very telling.
So I know we're getting to the end of this, but let me just ask a few more questions. Brennan versus Lally. You've seen them both now. Lally, actually, to his credit, got a few jurors on his side. What's your take? I mean, Brennan over Lally over Brennan. I mean, what's... I
mean, look, I know the easy way and frankly, the humorous way, because, Lally is just like the schlub, the lovable loser who walks in, like he's just, he's so milquetoast. He's so blah. There's nothing compelling about him at all. I mean, even David made an interesting point in that interview that I don't even know the man, in a case like this for 3 years, and I know nothing about him. That's impossible if he had any engaging personality. But that's kind of the easy, humorous way out to say, well, yeah, Lally got, allegedly 8 or 9 guilty votes and allegedly non-acquittals on counts 1 and 3. Although I think practically speaking, those were acquittals, if not in law, in fact, right?
Yeah.
But Hank Brennan is a much better lawyer than Adam Lally. The biggest problem for Brennan in this case is he was miscast. He should never, with his personality and his pugnacious nature, and his snivelly tone with experts. He was just so miscast to be the white hat prosecutor in a case involving this level of alleged corruption, police misconduct, and all this other stuff. And he just, to me, the irony is if he had been hired as the defense attorney years ago in this case, not that someone like Karen would ever hire someone like him, but he probably would have been great as a defense attorney in this case. And in going after the Proctors, the Alberts, the McCabe's, the other ones, as opposed to going after, Dr. Russell and Wolf and Rentschler and so on and so on. So I'm not going to tell you with a straight face that Lally is a more skilled attorney than Brennan. He's not. I don't think that's, again, I don't think Brennan tried the case very well, given his demeanor and some of the strategic decisions he did. And I think some of the poor judgment in his own presentation of evidence, the hoodie, the x-rays, all that. But I mean, Lally's not a better lawyer than Brennan. I come on,
I completely agree with you. I just know what's going around now. I mean, Brennan, that to me, right from day one, you can tell he's a better lawyer. Like you said, I think he was cast strong. And also, quite frankly, the defense made their case stronger and the Commonwealth made their case weaker, if there's any way to do that. But they did.
They did.
Because
no, go ahead. We're talking over.
No, because I mean, like Dr. Welcher, if you thought that helped the Commonwealth case, like it just that we all saw what happened there. It actually hurt their case. And then when Brennan, like you said, the cross-examination, this is what I said at the time. And again, I know you were, everyone asking you to come on their show and you're not able to watch everything that I'm saying. But when he was doing the cross-examination of La Posada, Wolf, and Rentschler, I said, he did a better job than Jackson, helping the defense.
Well, I had a running joke watching. I mean, La Posada, I said, stole his soul. I mean, it's like she just reached in, grabbed it, and you could see him just go. But, part of being a prosecutor, though, is also being fair. Again, you're the white hat. You're not, the role of the defense attorney is to, show reasonable doubt, even if a client's guilty. By the way, I don't believe Karen. I believe Karen's innocent. I don't believe she's guilty. I'm talking generally. Even if you have a client who may be guilty, your job is to ethically poke reasonable doubt, put it out there, and walk out. The role of the prosecutor is not to get convictions; it's to do justice, which may very well mean in certain cases not proceeding. And when Brennan came in, that was his talking point. My main charge is to guarantee that Karen Reed gets a fair trial and to put a full faith, all evidence out there and do that. And you know what? He didn't do that. And there were so many chances that he could have taken the off ramp and gotten out of this if he was wearing the white hat. And the best example is this. You jump in, you look at the first case and you look at like the whole Trooper Paul fiasco. I get it. They can't have that. It's a red flag. You say this is embarrassing. So we need to find an expert. But they should have searched for an expert agnostically. It's clear they didn't. They searched with we need to find someone who's going to tell us this was a car accident, because that because of the Aperture fiasco. Those are just, pay us this and we'll tell you this. I mean, does anybody think that's not how it works with Welcher and Burgess? Like, what do you need? And again, Brennan is an experienced, accomplished, skilled lawyer, and he knowingly uses, or authorizes the use of an incredible amount of taxpayer resources to hire these two guys, one of whom, as you know, is an academic fraud. And Brennan knew it because he didn't even ask him about it. He knew. He asked him all the other foundational questions other than his education. And that was going to be his data guy. And then Welcher is going to be this is how we're going to blow up ARCA, by having him dress up as John O'Keefe and like thrust himself with paint. And you say, at that moment, an experienced lawyer like Brennan couldn't say, what am I doing? I can't. And instead he doubles down. You saw, now in hindsight why he was so bent on trying to get rid of ARCA out of the case, not letting them look at Welcher or testify about Welcher's alleged testing. Even though he was saying, I welcome them, he was lying. He did, his mouth said this, but his actions said the exact opposite. And always trust body language over what comes out of someone's mouth, right? So there were all these ways he could have gotten out of this, and he didn't. And like you said, his cross-examinations of these key witnesses at the end were just bolstering and supporting the defense entirely. And
destroying Dr. Welcher in the process, like by insisting that Dr. Welcher did not do an accident reconstruction and had no idea how this happened. Like,
what
he
is
was
a strange thing to
that.
do for a prosecutor, wouldn't you say?
Yeah. So like I said, the case is very difficult to win as any prosecutor, which is why most of us would walk away from the case immediately and not even try it. He obviously got paid well. Seems like it's going to be close to $500,000. Okay. So that counts for something. And he must have, had some sort of belief in the evidence because, he, as a prosecutor, as a lawyer, you'd like to think ethically that you believe in your case if you're going to try to put someone away for possibly life. But like I said, yeah, I agree with you that I think Brennan was the better lawyer, and we just saw it erupt at the end of the trial in front of our faces. Let me ask you one more question.
Yep.
One more question, because I know you started saying something about looking into the Sandra Birchmore case, and the people have been asking me, okay, what are we going to be doing next? I said probably Brian Koberger. But I know there's a lot of interest in Sandra Birchmore and also Brian Walsh, but that trial's not happening for a little while, I think in October sometime. And a lot of similar players. So the problem with Sandra Birchmore, I've been telling people, is that I think it's a federal case, and we're not going to be seeing any pretrial hearings or trial or anything like that. So what are you going to be, looking at?
My interest in Sandra Birchmore isn't necessarily, the odds of there being a federal trial are low. The odds of there being an interesting, controversial federal trial is virtually zero. No, I'm interested in what happened here and the Norfolk County corruption. So trial or not, I'm talking about not necessarily the court case as, what the hell happened here, and follow the corruption. So, it's the same cast of characters that are involved in that. And I find that interesting. And it's the same cast of characters that are involved in some other 3 pending Norfolk County indictments that we won't talk about today that are of interest to me professionally and beyond just, chit-chatting about. But so that's my interest in Sandra Birchmore. It's the whole, how did this happen? How did this end up a federal case in the first instance? Like, why wasn't this just another straightforward murder prosecution in Norfolk County? Now, maybe they felt they didn't have evidence for that or didn't have a suspect. I don't know. But, everyone knows how they just swept it aside as a suicide, and it ended up being so much more, the missed messages, all that. That stuff's interesting to me. And I don't know that much about it other than what I've read. So I do intend to roll up my sleeves and take the plunge.
So let me ask you, I know you put out a question on there on Twitter. Is there any way to get documents on the Sandra Birchmore and Don't Say Pacer? Did anybody get back to you? Do you have a way of getting those documents? Because I'd like to see them too.
About 647. Yeah, no, I'll be happy to share them. Yeah, I gotta. Yeah, and the joke is, I say Don't Say Pacer because the last thing I'm doing, as you know, Pacer is a horrible website, and clicking on one PDF at a time and printing. I don't want to spend 6 hours downloading and clicking and then having them remind me that, like, we'll send you the 30 cents we're charging you on your monthly bill and all that. It's just easier if somebody has it. But yeah, no, I've gotten a lot of response. I haven't looked at any of it yet, but you'd be surprised how this online community, when the bat signal goes up, they respond.
Yeah. Okay. So please, if you don't mind, if anyone's listening, share the documents with me. I want to take a look at them. And if there's anything that I can provide in terms of analysis or insight, I'd be happy to do so. But one more question, because I keep seeing this question come up. Is Karen Reed going to get her Lexus back?
She was convicted of a crime, albeit a low-level misdemeanor offense, you know, I'm not sure. You know, in New York, they started a thing years ago where they would start seizing vehicles and like civil forfeiture. The NYPD would, as an instrumentality of a crime, and then they would negotiate, you know, to drop the lawsuit, so to speak. You pay a fine or whatever, and you can have your car back. Realistically, I doubt it. Does she care? I don't know. I doubt it. But you know, it was in theory involved in a convicted crime, albeit nothing to do with a homicide. So I don't know what the local people are doing with their civil forfeiture, or whether they ever, you know, whether they ever instituted actions against the car, seize it, or nobody cared. I was almost sweared. If nobody cares because it's just no one was paying attention. So the short answer is I don't know. And logistically, I would think she just doesn't care at this point. The car is, you know, it's out of taillight anyway.
Well, what'd you say about the bail also?
The bail, yeah. Bail, absolutely, minus whatever fees apply. But I mean, bail is not meant to be punitive in the sense of taking your money. It's meant to dangle it over your head and say, I dare you to run and lose this. But she would be entitled to get the bail back even if she's convicted of everything. I mean, the bail is not meant to be punitive when the case is over. So absolutely, she would get the bail back.
All right. Okay. So Mark, that's going to be it for today. Thank you so much for joining us. Maybe the next time we'll talk about maybe Sandra Birchmore, unless some other Twitter trolls or judges make some other asinine comments that we have to discuss.
You never know. You know, the day is young, so you never know. It could be today.
That's right. Okay. Well, thanks so much, Mark, for coming on. All right. Take care. I see that there are some comments. I'm going to go through some of the comments now. I appreciate it. I just didn't want to do it with Mark on. And some of them came when my father was on. So let's go through some of the comments. If you have any questions, you can put them in now. Sharon Smith, I have to be honest, when I first started watching VC, I was somewhat frustrated that he appeared to be leaning towards the Commonwealth. But as the case went on, I noticed a considerable shift. Well, what I will tell you is that what I do is that I try to come to every case that I'm covering as objectively as possible. I want to see the evidence, and if one side does something good, I will say they're doing something good. So if there's a good argument, if they have the law right, I'm going to say, whether I like the side or not, the Commonwealth has a good argument here. Hank Brennan did a good job. Like if there's something that there's to be complimented, objectively speaking, I'm going to do that. Even if I don't agree with their position, I'm still going to do that. And also, like I said, I don't take positions until I see all the evidence. Until I see all the evidence, I don't take positions anyway. So that's what I like to do, and I'll continue doing that with whatever case I'm following. Sharon Smith, thank you again for that. Lena on me, Attorney Alessi shouted you out. So I keep hearing about this, that Robert Alessi, and in that interview, that 5-hour interview, maybe it was less. Some people are saying it's less because he was going through super chats at the end. But some of those, he said something about watching Brother Counsel. So I appreciate that. And if you want to know why they won, I mean, now you have your answer. I mean, I think it's, straight. He just spilled the beans right there. Let the cat out of the bag. But all right, make it make sense. Happy birthday. We did that one already. Thank you for that. Jay Coop, Solomon has been my favorite. He is one of the favorites. Solomon is awesome. National trial order. Jay Coop, Brother Counsel got a shout out from Alassi. Oh, there we go again. Thank you. Benjamin Rowlandson, conspiracy to pervert the course of justice. Arca and Isaac Newton says there are charges to be laid, indictments to be made, and anyone who says otherwise is talking out of their butt dials. So what's the 411? It's a loaded comment. I'm not exactly sure what the question is there. But Jay Coop, can Karen Reed bring an FBI report and get all communications with Albert? Bring in third-party culprit? Are you talking about in the civil case? In the civil case, can they get the FBI? Well, they're going to have to do the same type of TUI request. Most likely they were not able to get any more of that. So whatever they can get from the feds, they can bring into their civil case as well. Sure. Whatever the feds will give them. Ross Beaver Diver, can we donate to the girls? Are you talking about the Radner girls? Not sure which girls you're talking about. Ellen Victoria Olsen, no, I love this too much. Thank you for bringing brilliance. Ellen from Denmark. Thank you very much. Deanna D'Amato Copeland, very impressed with your whole family, and thank you for sharing them with us. Respect to Solomon's daughter, honoring the loss of her friend. Yes, Solomon has a great family. He's a great man himself. He does a lot of great community service and work and gives back a lot. And that's what his family does also. So that's why you find his daughters already at a young age are donating or creating causes to help charities and things like that. Ex-cop would like to say Key Cycle 1162 was in MSP custody, though. Talking about that 1162 issue. We know some of the mentions there. Lori Pendleton maybe became a new member. Thank you for that. Ross Beaver Diver, Papa Counsel like ham sandwiches? No offense, LOL. Who doesn't like ham sandwiches? I mean, the problem is that he keeps kosher, so there's no ham sandwiches there. Amy's Positive Pathways, member for 3 months. Thank you. There was never an accident report made. That's a problem when you have the civil case. Amy's Positive Pathways also, medical examiner stated not consistent with a pedestrian strike. That's right. Scorty Bello said that. That's true. Ellen Victoria Olsen, no. Again, seriously, why am I so lucky? This is so great. We had a great show today. You got to meet Father Counsel. We had Solomon. We had Mark. Always love talking to Mark. Everybody loves Mark. Mark is the man. Tina T, they are unhinged. Yeah, some of these people are unhinged. It's amazing. I mean, it's just what's going on now is unprecedented. I mean, I don't think we've ever seen anything like this going on. And the whole Karen Reed case is unprecedented, so I guess we shouldn't be so surprised. Kanye Robledo, unless he mentioned he watched you. Ian Andrea and Defense Diaries. Again, I told you from the beginning, if they're intelligent, they'll be watching intelligent lawyers talk about this case. You know, it's the more heads you have in the room, the better. And sometimes when you're in the trenches, as we call them, when you're in the trenches, well, sometimes you think a certain way, and it's good to have somebody from the outside give their ideas. And when you can hear other lawyers who have been in trials before and have some ideas for you, it can't hurt. Definitely can't hurt. Smellel. At Brother Counsel, do you realize that Yannetti and Alessi said in their interview with Runkle that they actually watched your videos during trial? Okay, so I see the theme here, guys. I appreciate it. Ain't so plain Jane. The foreman's interview in the Boston Herald was all the validation I needed. They picked a great jury this time, and I hope the Commonwealth does their job and protects them. Thanks for today. Yes, if there's one thing that we should make sure and be overly careful and prudent about, it's protecting jurors, right? You want to protect this amazing system that we have. And if you're just going to let them get harassed or quote unquote intimidated, whatever the statute provides, we have to come down with that with the full authority of the law. This is no jokes. This isn't just, you want to stand outside and scream free Karen Reed and people get upset with you. That is completely different. You have jurors who perform a very important function of part of our criminal justice system. We cannot let them get abused. We cannot let people see them get harassed. We have to stand up for them. We have to protect them. We have to protect the system. So, yes, we should err on the side of caution and make sure that those jurors are 100% protected from any harassment. Larissa Harris, thank you for authentic yet law-based insight on this case. Your channel is one I know I could go to for the facts. Appreciate you. Bederow as well. He has spent a lot of his time making sure what I saw as injustices weren't brushed under the rug. That's right. Oh, I didn't show this. Here, let me show it. That's the comment that I just read. And yeah, Mark's been right there the entire time. And he was almost retained on this case. He was almost one of the attorneys there. Z. Sandra Birchmore, not only victim of sick policemen. Discworld Edgewitch, Mizzy of the channel, Mixed Up Girl in a Mixed Up World, runs the Justice for Sandra Birchmore page and has all the court docs. She's happy to talk. Okay, Mixed Up Girl in a Mixed Up World. So I'm going to have to look her up. Well, okay. Looks like that's going to be it for today. Thank you all for joining us on this Sunday morning / afternoon. getting to meet Father Counsel, getting to meet see again Solomon, and of course Mark. And we'll see if there's anything more to talk about with the Karen Reed case. I would love to have Robert Alessi on the show. I sent him a message. I hope he gets back to me. If you're watching this, Bob, send me a message back. Let's set it up. I've got some questions, more like strategy questions. And it's not going to be 5 hours. I can assure you that. That's not what we do on this channel. Again, anyone can run the channel however they want, but we try to get through the issues as fast as we can. And definitely will be respectful of your time and everybody else's time. So I hope that he does get back to me and that we can talk about some of the things, because there's something specific that I want to talk about Robert Alessi about. And I would love to speak to Alan Jackson and David Yannetti and Liza Little also. But there's something specific with Robert Alessi that I want to speak to about, because he kind of came into the case later. And it gives him a whole different perspective on the case. And I really, and he kind of came later, but I'd love to talk to him specifically. I'd love to talk to all of them, but I did reach out to him, and hopefully he will get back to me and we will put that together for all of you. So if anybody has any sort of influence with him, let him know. This is a great channel to come on to and to have a discussion with. Discworld Edgewitch, one more time, correction, mixed girl in a mixed up world. Okay, we'll have to check that out. All right, well, everybody, thank you so much for joining us. And what trial are we moving on to next? Everybody keeps asking me that question. I think it's going to be Brian Koberger. I already started looking into that trial again. I know it's coming up soon, about another month, a little maybe 6 weeks. If there's something in between, I know some people have been sending me emails about something in between. Maybe we'll do something in between also. But I already did one video on the more recent pretrial hearings in Brian Koberger. Maybe we'll take a look at Sandra Birchmore. If I see the documents, we'll see what there is to talk about there. But if there's anything else you want me to cover, let me know. Let me know what the people want. That's what we're going to try to give the people. So, but definitely, I think Brian Koberger, when it comes, we are going to be head first, knee deep into all of that stuff. So we'll see. All right. Thank you, everybody. We will see you next time.